if you're not, or if you are too old to remember Lenny Bruce, you won't be too old to remember the currently living person who made Blazing Saddles. And I'm going to talk about him in a second, because we recently had the governor sign 808 new pieces of legislation to make your life better. And I thought I would tell you a little bit about some important ones. But I wanted to say, you know, the great living Mel Brooks writes Blazing Saddles, and there's Governor LePet of Maine, you may recall him, and he sits there and they say, just sign here, Governor, and he signs, work, 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 work. It's not like that in California. The truth is that this governor and all governors get an individualized presentation on every single bill passed by the legislature. There is a legislative unit. If you go into the Capitol and you see governor above the office, it's known as the horseshoe because it's shaped in a horseshoe shape, and the governor's in the far back left. But he has a legislative unit, and in that ledge unit are deputy legislative secretaries that report to the legislative secretary, and they are assigned bills on subject matter. And they are expected to know the tiniest details of these bills because, agree with them or not agree with them, Jerry Brown is an active intellect. He is going to ask hard, penetrating, sometimes off-the-wall questions, and the ledge staff is expected to know the tiniest details of these bills. And by the way, they love their job because they are dealing with a very smart guy who will ask interesting questions. And they go into the office where he works, and there's this giant picnic table. And I mean giant, probably holds 30. And the ledge deputy will be sitting across the picnic table from Jerry Brown, and they'll go back and forth on these bills. And sometimes it's an easy call, and it'll take 1 minute. And sometimes it's a real hard call, and I'll talk about one of those today. And the governor will spend hours calling people, trying to figure out what to do with the bill. Well, spoiler alert, this one had to do with arbitration, and he vetoed it. And I think that was good and the right answer, but we'll talk about that in a second. So every year, the California legislature introduces about 2,500 new pieces of legislation, again, to make your life better. That is their product. I do lobbying, GM makes cars, Lowball and Lynch practices law. Legislators make law. They think that they are being productive if they're passing lots of law. Their job, in their mind, and it's true, is to identify problems, real or imagined, and propose solutions to those problems. I think sometimes they are finding solutions to non-problems. I think sometimes they are finding the wrong solution to a real problem, but they are trying to do the right thing. And if you met them, you would mostly like them, and you would agree that they are trying to do the right thing. It's not an easy job, although you may well disagree with them on a given bill. So out of these 2,500 bills, the California Defense Council, that represents civil defense lawyers in California, identifies around 150 of potential interest to civil defense. We work with many of the associations that you are involved with or are members of, the insurance associations, ACIC and PIF and the American Insurance Association and so on. And it's generally collaborative. There was one bill this year on which we disagreed, and I'll give you a little background on that when we get to it. So what I'd like to do is I'd like to talk about 6 bills that I think really matter. I'd like to talk about a couple of others that are not in the top 6, and then I'd like to talk for a minute about the big issue I see coming next year. Spoiler alert again, it's revenue and taxes that we all pay. And I think, demonstrate to you why that issue is relevant to us as lawyers, lobbyists, insurance representatives, etc. So these 6 bills, and they're all in your materials. Well, I think they are. I actually added one recently. But the first one is AB 555, and that relates to expedited jury trials. Several years ago, in an attempt to bring efficiency to civil trials, we enacted collectively a voluntary expedited jury trial system where you could stipulate with your opposing counsel to try the case under the so-called EJT system. And it would be a shorter presentation of evidence. You would waive the right to appeal, shorter voir dire, trying to get the thing done in a day. It was, by all accounts, a resounding failure. There is great disagreement about what caused that to be a failure. Some plaintiffs' lawyers blame defense counsel, some blame insurance companies, some blame the plaintiffs' lawyers for not wanting to do EJTs. But there was a general perception that there were some defects in the system. First, that the 3 hours to present the case per side was too short. Second, that the lack of appeal was too risky. Voir dire wasn't long enough, and so on. So the judicial branch came to us and said, what can we do to make the expedited jury trial model more successful? And I frankly thought that our friends in the insurance community would be a big problem. But here's what we ended up doing. First of all, there was a sunset date on the existing voluntary EJT system. It was going to sunset at the end of this year. That sunset has been repealed, so the voluntary system is now permanent. But that's entirely your decision with your counsel whether to do EJT. They did, even in the voluntary, lengthen the presentation of evidence limit. Instead of 3 hours plus voir dire, it's 5 hours including voir dire, so minor lengthening of the system. But otherwise, the voluntary system remains in place. The big news is we're taking a step beyond voluntary and actually making EJT mandatory for certain limited cases. And I use limited in quotes. The new law, AB 555, which, by the way, takes effect on July 1 and runs for 3 years until July 1, 19, to see how it works, is to make the EJT system mandatory for limited jurisdiction civil cases. That is, cases with an amount in controversy of under $25,000. But, and this is important, with some opt-outs. The insurance representative said, you know what, I think we're okay with this, but there are some kinds of cases that EJT may not be appropriate for. And those are actually listed in the bill. They are things like where punitive damages are sought, where there's potential excess over coverage, where there's a reservation of rights, where there's a claim reportable to a governmental entity, so somebody's professional license is at stake, where there's a claim of intentional conduct, and then a catch-all, well, two more, where there's a demand for attorney's fees, except a simple contract case. The fear there was there may be cases that have little tiny damages, a FEHA claim or some other statutory claim, might have little damages, big, huge demand for attorney's fees. You want those out. So a case that has a demand for attorney's fees, other than a contract, simple contract case, is outside of EJT. And finally, a catch-all, anytime that the lawyers can convince the judge for whatever reason that the case is not appropriate for EJT. So again, starting on July 1, we're going to try something new for 3 years, and that is have shorter, faster cases in limited jurisdiction. I mentioned appeal. There is no appeal in the voluntary, but in the mandatory, there is an appeal to the appellate division of the Superior Court. So, and that was important to insurers who thought, okay, it'll give us more comfort if a case goes south on us that we can put it in front of the appellate division on appeal. And with that, it was without opposition and was signed by Governor Brown and will take effect on July 1. And I think you'll see a common theme here of things that relate to efficiencies. And I'll get to a couple more in a minute. One bill that I did not put in your materials, but it's listed in the status report, is AB 560. This is a bill that may be slightly more controversial than the legislature knew. And basically, AB 560 says that immigration status is irrelevant in civil cases on issues of liability or remedy. Notice it's interesting, they don't use the word damages, but the notion is that a plaintiff's immigration status is not relevant to whether the defendant is liable or not, or to remedy. Some lawyers have suggested to me that that will end up being a big change, because sometimes the fact that a person may be subject to deportation is raised in the case, but this bill would say no more. Okay, AB 1141 deals with two distinct civil procedure issues. The first is summary adjudication. Some years ago, the legislature said, we're no longer going to allow summary adjudication of issues unless they completely dispose of a cause of action. We don't want to have a summary adjudication motion on was the light red or was the light green, unless it's going to make the case go away. We later said, however, if the plaintiff and defense and judge agree that it would shorten the case to summarily adjudicate this issue or lead to settlement, the judge can do it. Frankly, I hadn't heard about it a lot. Since we've been talking about it, I understand that motion is used with some frequency. The bill sunsetted, and frankly, I missed it. Once in a while, you just lose track of a law, and it automatically sunsetted by its own terms. This bill reinstates that summary adjudication of issues if the parties agree that it'll lead to settlement or a shorter trial. Now, there's another part of the bill that's potentially quite significant as well, and those are Section 998 offers. Another inadvertent change in the law some years ago made the law unbalanced. It said that if the defense made a 998 offer and the plaintiff didn't do better at trial, the defense could get both pre-offer costs and post-offer costs. But if the plaintiff made a 998 offer and the defense didn't do better, the plaintiff could only get post-offer costs. And the plaintiff's bar said, that's not right. It ought to be parallel. It ought to apply equally. And we ended up in a pretty extensive debate about how Section 998 works. The final agreement was, okay, we'll make it even, but what we're going to do is we're going to make both sides eligible only for post-offer costs. Because the fear was that, especially on plaintiff's costs, their pre-offer costs were too hard to know, and we didn't want to make ourselves liable for those. So 998 was made parallel for both on post-offer costs only. So those two elements of 1141 were the summary adjudication of issues and 998 post-offer costs. AB 1197 is one that I think you're going to run into right quick here, and it has to do with the relationship between national deposition services companies and people who arrange or who pay defense costs. Simple example, an insurance company retains a U.S. Legal or an Esquire or a Magna or a Veritext to do all their deposition stuff around the country. The Deposition Reporters Association said, well, the parties ought to know if there's a contract between the person funding the case and the deposition services firm. And so what the bill says, it actually amends section 2025.220 of the Code of Civil Procedure. It says that the deposition notice must contain a disclosure that a contract exists, let's use an example, between Veritext and State Farm, if the lawyer noticing the deposition is aware of it, or if the lawyer has been, and this word is important, directed to use a specific deposition reporter. So either if there is a contract between the services company and the insurer, or the services company and the corporation, or the services company and a law firm, and if the lawyer, or if the lawyer has been directed, it doesn't say encouraged, suggested, pleaded, begged, it says if the lawyer has been directed to use that specific deposition services firm, then that must be in the deposition notice. That takes effect in January. There is no new remedy. There is no new, quash the deposition, or no new right granted. But this notice must be provided if there's a contract or if there is a direction to use a certain deposition firm. Okay, SB 383 is a bill on which the lawyers and insurers disagreed, and I want to spend a little bit of time on this. It deals with demurs, and the judicial branch, right up to the Chief Justice, said, you know what, in our view, the system is getting overrun with demurs. In fact, some lawyers, particularly on the plaintiff's side, have called for the elimination of demurs, which defense says would be a bad idea. Those are important to help refine causes of action. When you get vastly overpled cases, you can't even tell what the gravamen of the complaint is, a demur is important. Don't take them away. But in LA, over a 2-year period, recently they had 24,000 demurs. And it's sort of idiosyncratic county by county. Some counties, like the one we're in, apparently are pretty caught up on their demurs and summary judgment. But some counties, you want a demur hearing, it's 9 months from now. So the idea was to require a meet and confer between lawyers prior to filing the demur. Now, I thought the insurance industry would have great concern about the EJT bill, but it surprised me that, in fact, they got okay with that one, but they were not okay with this meet and confer bill. And in fact, they were vehemently opposed to the bill and sought a veto by the governor. The insurance industry and other business groups, banks, builders, pharma, said this will slow down litigation and result in additional costs for defense lawyers to do these demurs. The meet and confers. The defense bar said, well, in many local courts, there's a meet and confer requirement already. It's certainly true in some of the complex courts. It is true in the federal system. It is not true that we're trying to pad our bills. If we wanted to pad our bills, a demur is a lot more expensive than a meet and confer, but we were not in agreement on that bill. The point that I'd like to make, though, is it's more than meet and confer, and in particular, The plaintiff's bar, with whom we negotiated, made a couple of, I think, significant concessions, which you ought to know about. First, the bill requires them to amend their complaints by the time the opposition to the demur would otherwise be due. What was happening was, I'm told, the plaintiff would wait until the day before the hearing on the demur, amend the complaint, and say, never mind. The judge and his or her staff would have worked up the demur, the defense lawyer would have been ready for the demur hearing, and it would have all been mooted out by this amended complaint. So the bill now says you got to amend your complaint by the time the demur opposition would have been due. Perhaps more significantly, the bill says now you get 3 amended complaints. If you can't state a cause of action after 3 amended complaints, the following standard will apply. The 3 amended complaints will apply, quote, absent an offer to the trial court as to such additional facts to be pleaded that there is a reasonable possibility the defect can be cured to state a cause of action. In other words, don't keep amending your complaint word by word. Unless you have something real, stop it. And so this is the first time there has ever been, in my knowledge, a limit on on amended complaints in California. So you get your first complaint and you get 3 amendments, and at that point, no more unless you can explain to the court what new facts you have that you haven't pled before to state a cause of action. So it's really kind of a demur reform package. Is it perfect? I don't know. What we ultimately did is we put a 5-year sunset on that bill to see how it works. And it's going to be pretty easy to tell. Do demurs go down or don't they? And I guess within the webinar I can take a question. Sir?
Yes, sorry about that. I was just curious, during the discussions of this, was there any discussion about the effect of how much time you have to respond? A lot of times carriers are going to get these complaints kind of late in that 30-day process. So there's not always a lot of time for meet and confer. So was there any discussion about maybe having a method by which this meet and confer letter starts the time?
Yeah, the question was, has there been or was there discussion about time periods where the defense and insurer may get the complaint late? And the answer was yes. There is a process for an automatic extension if you put in a simple declaration that there wasn't time to do the meet and confer. So you get an automatic extra 30 days. So we've tried real hard to address the concerns. We did not get to agreement on it, but the governor, who is very into efficiencies and what can we do to make the system work better, signed the bill. Finally, SB 470 deals with what judges have to do with respect to summary judgment motions. There was a famous case recently known as Reed versus Google, which basically said that evidentiary objections to summary judgment, which are not ruled upon by the judge, are deemed overruled. What was unclear was the responsibility of a judge. Do they have to rule on every evidentiary objection or not? And we were told that judges were routinely being handed 600 rote objections to evidence in summary judgment, and it was unclear what the responsibility of the judge was. This bill says the judge need only rule on material objections to summary judgment, and that objections not ruled upon are preserved for appeal by the parties. So what we have this year, and it really was one of the busiest years in memory on civil procedure, was this theme of efficiency. Can we get some summary adjudication of issues going if it'll shorten the trial? Can we meet and confer and try to weed out some of the demurs that may not be necessary? Can we do more trials by expedited jury trial? And that sort of thing. And that was a theme for 2015. And I think, like I say, one of the busiest years in my experience on civil procedure. Now, there were some other bills that I'd like to talk to you about that you ought to know about that are not printed out in your materials, but are on that status report numerically. The first is AB 87, basically says you may not, we always knew that you could not use race as a basis of a peremptory challenge in fashioning a jury. This bill says all protected classes may not be used, so age and sex and that sort of thing. It limits the use of peremptory challenges on grounds where you have protected classes. AB 304 cleans up California's sick leave law. You may be aware that as of July 1st of last year, we have a brand new sick leave right for all private employees in California. There were some problems with the law, but as of July, every employer in California is required to include in every pay stub the number of sick leave hours accrued by the employee and the number used. What was unclear was how you calculated the sick pay for the time the employee took off. The bill said you had to do a 90-day look back to see what the employee had earned over that prior 90 days and do a pro rata for what he or she took as time off. I was told that not one employer in California could do that 90-day look back. They simply don't have the software necessary to do that. So the bill, which makes some other technical changes, said you don't have to use that 90-day look back. You can apply the employee's regular rate of pay. For those of you who are into HR issues, regular rate of pay is apparently a term that people know, in common use, and you can pay the regular rate of pay for that time. Another bill that you should know about, although I hope it doesn't become a matter between insurers and defense counsel, but it is a big change, potentially, is SB 358, and it deals with gender pay equity. California has long had an Equal Pay Act. What we did not have was a Comparable Pay Act. So an employer was responsible to not use sex, gender, as a grounds for paying one employee more than another. But we never had a Comparable Worth Act. We didn't ask employers to decide, is that work comparable to this work? Because the fear was there would be a constant debate, is that teacher comparable to that social services person? And that you would have these decisions that were impossible to answer. What this bill says is we're not going to use equal pay anymore, but we are going to require an analysis of substantially similar work. And it's going to be across locations. So if a company has people in LA and somebody in San Francisco, and they're doing substantially similar work, and that is not defined, the employer is going to have to come up with explanations for why the, typically I guess, woman is making less than the man. And they're going to have an affirmative defense if they can show, well, we did it on the basis of seniority or merit or whatever it is that was not gender-based, but it's going to be up to the employer to demonstrate why that pay disparity exists. This is a bill carried by Senator Hannah Beth Jackson from Santa Barbara. It made all the news, national news, because it starts to edge towards this comparable worth concept. The Chamber of Commerce actually supported the bill. There is great debate among lawyers about how big a change is this, how much litigation is going to result. But I was at an employment law seminar this morning in San Francisco, and some very august defense employment lawyers believe that it's going to be big, it is going to result in litigation. So I wanted you to know about it. Okay, now, where are we headed? Every year, the legislature, as I indicated, introduces some 2,500 bills. I think the watchword for 2016 is going to be revenue. We all, as Californians, when California went into the big recession several years ago, collectively enacted what we know as Proposition 30. And that imposed temporary increases on income and sales taxes. Those increases are scheduled to expire or sunset at the end of 2016 and the end of 2018. And if they sunset, the state loses somewhere around $8 to $10, $11 billion. Big money. It has an obvious impact, for example, on support for the courts. If the state general fund is down around 10%, then you can expect further court closures and that kind of thing. So a lot of discussion about what do we do to replace this 8 to 10, 11, 12 billion dollars. Some say you do nothing. It will replace itself because the economy is growing. And it is true, the economy is growing now, but if you talk to Jerry Brown, and lots of us have, he's absolutely convinced we're headed for another recession, and he, at least, doesn't want to be governor while 10 or 12 billion dollars goes away and he has to close down services again. So the discussion is, what do you do to replace the money? And those of you from Sacramento may have been reading about this, but big labor groups, including SEIU, teachers, and others, the first thing they're talking about is extending or making permanent those Prop 30 taxes. That's the simplest thing to do. If that doesn't work, some say it is time to make changes once and for all in what is known as the third rail of California politics. Anyone know what that is? Proposition 13. That since 1978, we have had property tax limitation pursuant to Prop 13, Article 13A of the California Constitution. Because it's in the Constitution, it would take a ballot initiative to change. And what do they want to do? They want to create what is known as a split roll. And the split roll idea is we're going to treat residential property different than commercial property. And residential property, we're going to continue to reassess only when a change of ownership really occurs, when you or I sell our house. But commercial property, which is argued turns over less frequently, we're going to reassess on some periodic basis, every 3 years or 4 years or 5 years, in order to gradually bring it up to market. Well, the business community says if you do that, that further puts a nail in the coffin of the business climate in California and will cause more companies to leave and go to Texas or go overseas or go somewhere other than California. So that split roll idea is explosively controversial. Okay, the third idea, and this is where we come in, is sales taxes. Now, sales taxes, historically in California, are only imposed on product, tangible goods. Well, as the economy changes to a post-industrial service-based system, the services I provide, that Lowball and Lynch provides, that everybody, we're a service-based economy now, are largely untaxed. And so the idea is, and it's reflected in a bill, SB 8, the idea is let's extend the sales tax to services. And the proposal, and it hasn't been really fleshed out yet, is to extend that sales tax to all services except health care. Laura was talking about health care issues. You know, we're all paying a lot for health care. They don't want to drive up that cost anymore. And education. It's already too expensive to go to college. You don't want to tax that. But let's tax every other service except health care and education. Now, that would convert all of us instantly into sales tax payers for the services we consume, whether it's nail salon or dog care or you name it, and sales tax collectors and remitters. So Lowball and Lynch would add money to their bill. I would have to add money to my lobbying fees. That's, I think, going too far. It would be an issue of monumental complexity. There's only two ways to create the tax. You either have to get the legislature to do it, 2/3 vote, legislature will not do that, or you put it on the ballot. And there's only two ways to put it on the ballot. I don't know if you've ever thought about this, but all the things we vote on statewide ballot, there's only two ways to put it there. It either gets put on by the legislature with a 2/3 vote. Well, they can't get 2/3 to put it on the ballot. If they got 2/3, they wouldn't put it on the ballot. They just pass the tax. Or you gather signatures. Here's my final prediction. 2016 is supposed to be an epic ballot for us all as voters to deal with. And there's two reasons why. First, turnout. It is going to be a presidential year. Those who want to think about sales tax or split roll or other tax issues want Democrats to come to the ballot. And when it's a presidential year, more will. And signature requirements. Turns out the number of signatures necessary to put something on the ballot is tied to the prior gubernatorial election, which you may recall the election of 2014, Jerry Brown was essentially unopposed. Turnout was very low. That means the signatures required is very low, hundreds of thousands less than in a typical year. Well, you need to gather fewer signatures. That means you hire fewer people to go put their ironing boards out in front of Rayleigh's. That means it's cheaper to qualify an initiative. And so they say that the 2016 ballot, which will be on us 1 year almost to the day from now, could be an epic ballot on revenue, on marijuana, on minimum wage. All kinds of things could be on that ballot. But I think in the legislature, much of the discussion next year will be about money. We had a big year on civil procedure. I appreciate your listening to me. I would like to thank Lowball and Lynch for having me. This is what I would call a legacy-type firm within the organized defense community in California. This firm matters. That's why I'm here. And I would be happy to answer any questions that you have. Thanks for having me.